The following interview is in English. I am Alexander Platteeuw from A+ Quality and I am your host for today. If you want to listen or watch in your own language, please know that this interview is fully subtitled on YouTube. My guest of today has a degree in law and has been partner with various law firms. Today she is partner and food lawyer with Food Law Science and Partners based in Brussels, where she assists clients throughout the food chain with issues ranging from food labeling, health and nutrition claims to innovation. She also helps clients in the food and feed area obtaining European authorization for new additives, enzymes, and novel foods. For that, she regularly works with institutions, European and national professional bodies, and commercial organizations. Not only that, she is a frequent speaker at international conferences and is one of only 4 chambers and partners ranked attorneys in the EU-wide agro-food regulatory category. She's also recognized by the Legal 500 in both Belgium and France as a leading individual in the EU regulatory category. Wow. With such a curriculum, I hope to never have her as an opponent in court. Can't wait to start this interview. Welcome, Katia Merten-Lentz.
Thank you, Alexander. With such an introduction, I can leave. Everything has been said now. Well, thank you.
Anyway, I still have
very
questions.
It's very flattered. So.
Okay. Katia, let's go back to your start. What attracted you specifically in food and in food safety?
Coincidence and life. It all started 31 years ago. My background at university was based on European law, which at the time was something highly specific. And my first job in a law firm in Brussels was to join a former agent from the European Commission who, after retiring, decided to create and develop a department dedicated to agri and agro law.
Okay.
Which was so new, so innovative.
Okay.
So I cannot say that we created literally this area of expertise, but not far.
More or less.
We really were a pioneer, and we really pushed and were at the beginning of the story of this area of expertise. Yes.
Yeah. Very nice.
And then per curiosity, I just followed because when I started, we were in the middle of the cow crisis, the mad cow crisis, so food safety was in the center of the attention of everyone in Europe. And so I would say naturally, I followed the adoption of all the rules which now make the food law framework. That's the beginning of my story.
Okay. So today in Belgium we have the federal authorities, the FAVV-AFSCA en français, who has its mission of protecting the consumer against any health issue caused by the consumption of food. But let's say a consumer is confronted with an unsafe food. We have now the Nestlé story in the news. What can he or she do legally?
Okay, I'm not the best place to answer your question because we are just between you and me. I can tell you everything. I'm usually on the side of the companies.
Of course.
Of course, I can provide you with a legal answer, an official answer. Definitely AFSCA, FAVV are at the disposal of the consumers associations to gather, to receive any kind of complaints, to investigate, to open an investigation, to sue the companies, to ask for some analysis, or for anything, everything. So any kind of unsafe, even unfit products which are already on the Belgian market can be, sent to the AFSCA FAVV to be withdrawn or recalled. So,
but imagine I am a consumer and then I say, okay, my baby became ill after eating this product. I can bring a company to court. I can.
Yeah, sure.
I can sue a company.
Of course. All this is based, regardless of the fact that we face a food safety case. It's very straightforward on a legal basis. We are back to the principle of there is a fault, there is a damage, and you need to prove the causality.
Yeah.
Okay. Yeah. So once you have the justification and a robust demonstration of these three facts, if you, I mean, a consumer feels strong enough to sue himself, a company, fair enough, go. But usually it's better to ask an association or to go to the. I think I'm sure FAVV-AFSCA has a center point of for any kind of complaints. So and it works very well. Yeah. But again, please, another question.
Okay, so from the other side, let's take the example of placing a product contaminated with Salmonella on the market, resulting in mortality and sickness. Who is responsible? So I know there is personal liability for people on the organizational chart of the company being the source of the problem. But how does this work in practice? I mean, can multiple actors in the food chain be held responsible? Is the food safety manager in a company also liable?
Okay, here you ask me one question, what sub question into one question. Yes. I would say, if you just leave me two more minutes to answer completely. First of all, for a consumer, I mean, facially, primarily, they can sue, and they have to sue the food operator under whose name the product was placed on the market.
Exactly.
First of all,
who is on the label?
I would say Danone. I don't say Nestlé. The name, the brand, the brand, and plus the name. And that's it for the consumers. Okay. Now, I mean, in the back office, along the food chain, and we know since the HACCP scandal, you remember, it was like a discovery of all the trading chain along the food chain. Yes, definitely, it's not just Danone plus a farmer plus
suppliers.
There are so many suppliers of ingredients, transformers, and suppliers until a final product is placed on the market. But again, the consumer will sue the brand, the industrial who has placed on the market the product. Then, if this industrial is not liable, is not accountable, is not the responsible of the unfit, or how can I say, uncompliance, the problem, the uncompliance of the product, it's up to this company, this food operator, to sue his turn his suppliers and the supplier of his suppliers, the one who is responsible of the contamination, of the wrong delivery of information, everything. I should have maybe started with this remind along the food chain. It's the most important principle is solidarity. From post-harvest, the very first raw material, until the placement on the shelves of a retailer. We could have thousands of traders and everything. We don't care. The thing is each step, each operator along the food chain plays his role fully with conscience and seriousness. Normally, the zero risk, the famous one, should be guaranteed at the end. Okay, so it's a question of solidarity, of transparency, of full delivery of full information and accurate and compliant product until the end of the food chain. So back to your question. Now, Nestlé or another company, they turn to sue but on a contractual basis. Okay. So this is one part of your question. The second is now internally. And I think you mentioned it's a question of a chart, an internal chart of the structures, the organization, the internal organization of each company. It depends. More generally, when it comes to something very serious, it goes up to the CEO.
The top.
Yeah,
exactly,
because the other people involved usually have just done their job.
Yeah.
Okay.
Yeah.
But the one at the end who has to be responsible, and I do not say that this one didn't do his job, but at the end, one has to be responsible, and it must be on the top. So
but he has personal liability. I mean, he can be sent in person.
He can be. Normally, first of all, he's liable and accountable because he, on behalf of his company, his or her company. But if there is something, a negligence, and something we can blame him of, then he could be personally liable. And when it comes to jail, to criminal sanctions, it could be on behalf of his company, but the company cannot go to jail.
Exactly,
so
exactly.
Somebody has to go to jail.
So they will pick him.
So please, who would like to?
yeah. But then on the other hand, I'm just thinking worst case now. This CEO says, yeah, okay, but I asked my food safety manager to do this and that. She didn't do it. So can then the food safety manager be held liable?
Theoretically, yes, but it's on a case-by-case basis, and based on my experience, generally, it's really difficult to demonstrate a very serious negligence or fault behind
if it
a
would
situation.
Be falsification,
really something like
fraud,
that.
then you could say, okay,
but
it's you.
If it's just a quality manager who thought he followed the rules, but he missed something, it's still human. So no, it's not something strong enough to sue him on a personal basis.
Yeah.
And look at some other precedents and case law. So often CEO was dismissed after scandal, and
Or in the US, Stuart Parnell, who was sent for 27 years.
We always need to cut one head, and
that will be the top head. Then. Yeah. Now we were starting from the principle that the consumer sues a company. It can also be the AFSCA,
of course,
who sues the company, of course.
Generally, it's AFSCA.
Generally, it's AFSCA.
I know very well AFSCA.
I imagine.
We exchange on a very regular basis.
I would imagine. What are the possibilities if a food processor doesn't agree with the findings made by the AFSCA? The AFSCA says, I'm taking you to court. The food company says, oh, pardon me, but the mistake is not mine. It's a Chinese supplier.
Alexander, is it a real question? You don't have the answer? They come to me immediately. Help desk, Katia. 911. No, to myself or to my company or to somebody else. But I mean, it's their full right to contest, to challenge an FSCA FAVV decision. Okay, and I'm used to challenging FAVV position because it happens more and more often now that FAVV consider that they are better in the assessment of the situation than the business operator themselves, and that when AFSCA says something, it's better than the assessment or the scope of a recall, for instance. And AFSCA said, no, you have decided to recall, 5,000 products. Okay, well noted, but we consider after a very quick analysis that you should recall 10 times or 20 times this product. So it's sometimes it's very violent. Okay. And generally it is built on a threefold approach. First of all, you absolutely need to assure and reassure AFSCA FAVV that you have identified the origin of the crisis. Okay. It seems logical, but it's okay. But it's immediately, yes, something. Hello, AFSCA FAVV, we are on something has just happened. We have immediately investigated, and yes, we are on it. We know precisely what happened and why. Okay, first. Second point is to say, based on what and why, we immediately stop. So there is no risk of recurrence. It's always we put when a roll on a wheel of your bike, you put I don't know, the rustine in French. But never forget the third fold is to say to AFSCA and AFSCA FAVV, and it will not happen again in the future. And if my understanding of your background is correct, it's something related with HACCP, with all the food safety, but on the technical and scientific side. Is to say it is now. This is now
we have taken preventive measures and
critical control point, highly critical control point, and we take very precise and definitive measures. Okay, and normally, if you follow, there is no normal situation, but fingers crossed so far, it works pretty well. When you are strong enough, based on this structure of challenging the FAVV decisions, plus a very detailed scientific risk assessment, they will leave you manage the situation.
Yeah, touch wood. Yeah. One other topic that a lot of my clients struggle with is the jungle in the EU legislation. And the link, or let's say the absence of it, with national legislation. I give you an example. A Belgian food producer has to comply with, of course, the EU and the Belgian legislation. Now he wants to sell his product also in the Netherlands. But in the Netherlands, since the 1st of January, you have now the PAL, the precautionary allergen labeling law. So, I am producing here in Belgium, so I don't have to deal with the Netherlands legislation. Now I want to export to the Netherlands. But there is the principle in Europe of the how do you call it? The
mutual recognition.
Mutual recognition. Explain to our listeners in such a situation how a company has to deal with that.
Yeah, it is a very interesting question. I need. I should need more time, but in a nutshell, the principle of mutual recognition is a very important one. It is its purpose is to guarantee the good trading and the circulation of goods all over Europe, and to harmonize and to make sure that everything is okay within the market. But on top of this, to make sure that one member state respects the other member states. There is normally no hierarchy among the member states. You can say French rules are better than Italian ones or Dutch or Belgian one. This is a principle. But when there is a principle, there is quite often, not to say generally and always, an exception. And the exception to the basis, it means principle. The principle of mutual recognition mean that a product which has been lawfully and properly placed on another market, European market, this product is legal, is compliant. Automatically, there is a presumption of legality, of compliance. So, based on this presumption, it is supposed to be legally placed as well on any other market. It was your question. What about a fully compliant Belgian product, which you would like to place, which you would like to place on the Dutch market? As I've just mentioned, the exception or the limit to this principle is safety. One member state is always, in theory, able and allowed to deny the access to his market based on safety motives. It's a bit crazy. It means that the Dutch people are more sensitive. I always use to fragile than the Belgian one, for instance, in your example. And my answer would be, I'm sorry, but yes. Because when it comes to safety, a member state, again, is still allowed to put in place some legal obstacles, some extra technical obstacles, which officially are supposed to to protect the safety of their citizens. Remember a total different example than the French one. Just not to say we have something against the Dutch, our Dutch compatriots. You will remember, I'm sure, in France, when it comes to the BPA, bisphenol,
Yes,
okay?
bisphenol A,
And France, out of the blue, decided that no way, stop of everything.
Yeah.
You stop placing, you stop producing, even you stop exporting, but our Conseil d'État decided, you went too far. This is not possible. So we
Draw back.
draw back. And but still, France kept a no-go on producing and placing on the French market. And the story after that is the whole Europe followed. Okay,
Yeah,
so
in that case, yes, yeah.
And
yeah,
this poll is maybe a bisphenol case. I mean,
yeah, but they will go in the same sense. I think.
Because it makes sense. It's not so. Honestly, it makes sense. It's pretty smart. I work. I'm used to working a lot with allergens questions and umbrella claim
May
contain, and there are too many issues around these umbrella claims, and so their position.
I know, but in the meantime, we have this period of I have to make an extra label for the Dutch market.
I know. I know.
But
so you ask me.
Summary: Holland can say we refuse these goods on our market because it doesn't comply with our national legislation.
We can.
Unfortunately,
Belgian food operator can always try, because there are many, systems and legal avenues to challenge when member state provides a no-go. So we can try. It's too early to see the consequences and to assess the situation.
It's
but just
3 weeks
on the spot, on the spot.
Mm-hmm.
This is my answer. Okay.
Yeah. Another case from 2020 was the ethylene oxide case, the ETO. Personally, I remember that quite well, with the sesame coming from India, and in India they had disinfected their containers. Which was
a highly prohibited pesticides.
Exactly. And then it was first sesame, and then it was guar gum, and then it was also Pakistan. And what a chaos. We were faced with huge recalls, although at that time there were no legal grounds for it at first. Can you guide us through this principle of authorities forcing a product recall even if there is no legal limit on a certain substance?
Be careful with your legal. You said legal rationale or legal basis. I do not agree.
Okay.
First of all, first comment. Yes, of course I remember, and I'm still working on cases.
Oh my God.
Yeah. On cases, on ETO cases. Look, first comment. It was a chaos. Yes. Why? Simply because this sesame seeds were processed in so many products. So we were just talking about the long chain of trading and intermediaries. Like that. This is a perfect illustration. And first, you can say, I don't care. I never eat the sesame seeds. You would be surprised. You eat a lot of sesame seeds. So the reason of this chaos is because almost all the food chain basically
was implied.
Yeah. Okay. Yeah. So first. Secondly, when you say no legal basis, the thing became very touchy when it comes to very processed foods.
Mm-hmm.
And then, despite the fact that the food operator knew that he had bought ingredients coming from India, okay, because you have a full transparent chain, okay, so they knew for sure, but they made a risk assessment, and the result of the risk assessment, in other words, the result of the analysis, didn't show any traces of these residues of pesticides. So in a more common situation, normally, back to, I don't remember your questions, how does it work when you would like to challenge an FAVV decision? Normally, based on, I identified the crises. I stopped, I made my risk analysis, and it's okay because it's far below the level of detection or something. And for the future, I will never buy again something from India. That's being said. Bye-bye. Thank you for coming. Okay, usually it works. But it's typically an example where it didn't work.
Yeah.
Why? Because it was so huge. And the most cautious among the member states, the syndrome of the best student. I'm French, so if I can criticize my country, it's objective. We suffer generally from the syndrome of the best student in the class. Yeah. And you always would like to show that, yes, we were the first, and we
are the most severe.
Yes, we have the highest standards of safety and things like that. So among the member states, France was particularly cautious, and DGCCRF decided out of the blue that from now, very day one, as soon as a business operator knew that, as I said, a supplier from a supplier bought something from India, they were taught officially, firmly, to recall, to destroy, to everything. And they didn't care about any risk assessment, despite the fact that you could provide, there was no risk, that there was no traces, that they were diluted, and so on. Belgium took another position. It depends. We had so many different positions. That's one of the other reasons we are still with pending cases of consequence, legal action, and things like that. But at the end, not at the end, but not enough quickly, or the European Commission reacted and decided on behalf of all the member states. Because at the end, at the beginning and at the end, we are supposed to be one market. Okay, so when we face such a situation, the European Commission should react without delay, which was not the case. And the European Commission left some time and some space to the member states. So unfortunately, it's not a question of legal basis or scientific. It's a question. It was more politics.
Yeah.
My humble,
with the huge consequences for the food price.
Sure,
process.
It was a disaster. You talked about chaos. That it was KO for some of them.
Huh? Which evolutions in European food law keep you busy the most at this moment?
Food safety, of course. Honestly, because I would say since COVID, but I don't think that COVID has really something to do with this. But it's something on my timeline. It's like
it's a mark.
It's a mark on my timeline. More or less since COVID, more and more often, as I've just told you, AFSCA, DGCCRF, and almost everywhere in Europe, the National Authority of Control tend to decide on behalf of my clients. Even if I think they did everything perfectly, as perfect as they could regarding the circumstances. But in other circumstances, by the past, the National Authority would have said, "Okay, thanks for informing. You respected the general food law. You informed us without delay. Thank you. Okay, we keep an eye on you. Big Brother is watching, but it's okay." And now they came and say, "Okay, it's okay. No, blah, blah, blah. Our gut is telling us that no, you should remove precautionary principle to an extent you cannot imagine. It's a big umbrella. You see, and they don't care. They're not business oriented. So in our defense, we cannot say, "Have you any idea how much it costs?" But it is an impact as well. And when it is not justified,
no, come on.
You kill a business just by application of the precautionary principle. And so I stand always firm on the side of my clients to change the position. And
okay, so in the EU we have this precautionary principle. If I am correct, in the US they start from another point of view. A food product is safe until the opposite is proven. Am I correct there, or am I wrong?
Do you have some bodyguards, or if the US? You're very brave, Alexander, but I fully share your point of view and your approach, and I don't care. Often, even when I have a talk in the US, I mention that we are proud within the EU to have the highest standards of safety because of the solidarity all along the food chain. And yes, you're fully correct. The approach is less radical, is more who cares until it comes to the placement on the market. But then it's a disaster. Remember, they have the class action.
Yeah. Then it's
class action
all the
is
way.
Such a strong system. It could totally destroy the reputation and a company. The reputation definitely, and the company, because the result of a class action means billions of dollars to pay for the company. So the approach, the US philosophy is a bit different. But to be honest, they tend now to come closer to our system and to be more, I would say, more on the control all along the food chain. Now they have they seem
have
to have
looked at
realized
the EU.
The notion, the concept of food chain means something.
Yeah.
So we
That's
cannot drastically
idea.
say that we have a EU approach, we have a US, which are drastically different. No, not anymore.
Yeah.
But it's a good point.
Yeah, well, okay. I just wanted to be sure that I am on the right track. Yeah. As a Belgian food industry, what can we expect for the future from UK legislation? They have left the EU.
Yeah.
Will it continue to follow the EU approach, or will they move towards their own system or towards the American approach? I don't know. What's your idea?
I have my perception and I have my experience. Altogether, I would say that since Brexit, despite several announcements, which for me looks like wishful thinking, they said we will move away from Europe. We would be, a sort of paradise and heaven for food business. Everything will be, more flexible, more agile, more open to innovation and things like that. For me, it's just wishful thinking.
Yeah, that
concretely,
won't work.
where do we stand today? They cannot tell their citizens that we totally move away from the European food safety standards, which we keep talking about them, which are good, okay? Because they put them at risks to weaken the trust of their citizens in the UK systems. The UK citizens are okay. We're satisfied and we're used to having this protection. So it's difficult to convince the UK citizen that definitely we will change. Yeah, like that. We are talking about
that won't happen very fast.
No, and we are talking about safety. So first reason, okay. Second reason, UK cannot digest. And anglicize. I've just made up the word, the verb, but create from scratch a new system, a new own UK system. Based on what?
What? Yeah,
based on exactly. What? And they have no time, not enough sources, not enough, nothing enough. Okay, no time, no money, no sources. And for me, I'm all a bit pushy. But third reason, another very pragmatic one, is basically because if they drastically change their framework and their philosophy of safety, it means the end of import-export with the EU.
Yeah.
Because we'll say, our safety, we would like to protect our safety. You do not follow anymore our rules. It's okay. You are like Chinese products. So it will really mean the end of something like a fluid and a smooth trading between the UK and the EU. And despite their proximity with the US, UK, Europe, we are close.
It's still a difference, of course.
The trading is quite important.
Yeah.
So I think we will they will keep following our line.
That's
makes
my
sense.
opinion.
That makes sense.
Yeah, exactly.
That makes sense.
Exactly. Yeah. Now, food safety legislation, that's a very specific topic, as you mentioned it half an hour ago. Do judges in court always fully understand the nature of a case?
Difficult to say. Always, it's always a case-by-case interpretation. But I would say yes, not so badly.
Did you see it evolve over time?
Yes, and how can I say the judges, the legal basis and the reasoning, the rationale is really straightforward. Is, as I mentioned, fault, damage, causality, and regarding all the scientific aspects, the highly specific regulatory aspects, they can ask an expert if needed, and then back to the implementation of the rules, and it works. It works pretty well.
Okay. Yeah.
They do the job. Seriously.
Good to hear. Yeah. If you could give one legal advice to food companies, what would that be?
Seriously? Alexander, it is so tempting. No, seriously. It's the last question?
That's my last question.
So I need to say something very
touchy. Yeah.
No. Something people will never forget. No, seriously, I would say the risk zero is something consumers have in mind. They are sure that normally they deserve a zero risk food product. Okay, so when for a food operator, they are supposed, it's a parallel of this obligation, this commitment, they are supposed to have a very, very good understanding of all the food requirements. And it comes to something new, very innovative, or when they have some doubts, please do not place the product on the market before asking an expert, before making sure that your understanding is correct. In case of doubts, please do not do. Because it will be so damageable, or it might be so damageable once it is placed on the market. Because I noticed before court, during a hearing with FAVV-AFSCA, it's always the same reaction when I start with my clients to defend our position, and as I say, okay, but at the beginning, who forced you to place on the market? Okay, you pretend to be a food business operator, so you are supposed to know everything. You pretend to place on the market something. You know the first requirement, the very first requirement of the General Food Law Regulation. It is only 100% safe food should be placed on the market. So if you cannot guarantee this zero risk, you do not place, and that's it. And we would not be there discussing and trying to challenge our decision. And so I never forget this approach.
Excellent. Thank you, Katia.
Thank you, Alexander. It was very, very interesting to exchange with you.
Same with you. Thanks for this fascinating insight in the world of law. Keep up the good work in defending our food chain operators and to keep our world a food safe place. After all, better food safe than sorry.
Yeah, sure. Good.
To our listeners, if you like this interview, please subscribe to my channel and like this video. Spread the word. See you in the next episode of Better Food Safe Than Sorry. I'm Alexander Platteeuw from A+ Quality, and I'm here to help you with all of your food safety questions.